All right. Good morning, Council. We have our third case on the docket this morning is Bachman versus Cincinnati Children's et al. Good morning, Ms. Mitchell and Mr. Winter. Mr. Winter, you'll have 15 minutes to argue. How much time would you like for rebuttal?
3 minutes seemed to be a good number on the other two. Let's try that here.
That's a good number. You may proceed when you're ready.
Thank you, judges. Good morning. I'm Bob Winter. I represent the Dieters Law Firm and Ben Moran. The court should be aware that Mr. Johnson's passed away and his estate hasn't been brought into the case, and I do not represent Matthew Hammer. What we have here is I think when we started this case before, the issue was initially brought up was why did we get into the situation that we did get in. Back in 2014, negotiations were going on trying to settle the children's hospital cases. And there were many plaintiffs who had sued Children's. During those negotiations, it came about that several plaintiffs had surgeries performed at Christ Hospital while employed at Children's. Some of those cases had been commenced against Christ Hospital, others had not, and some had not been commenced against Children's. We were concerned about, my predecessors were concerned about statutes of repose. We only had 4 years to commence litigation, and one method that we used to get cases commenced is to do what we did in the Baker case in the Court of Common Pleas, and that is have a mass lawsuit. And
well, let me ask you that, because this is something I've never understood about this case.
Yes, sir.
Is, it was initially filed against Children's, then it was dismissed, and it was refiled in March 2016 against Christ. But at that point, weren't there already all of these pending cases against Christ in individual cases?
Yes.
But then the issue is, like you're saying, you needed to do it for statute of repose or statute of limitation purposes, but that doesn't make sense to me. If you already had pending cases, the statute stopped running.
Because we had to bring in Children's in many of these cases, because Dr. Droney was an employee of Children's at the time. He was doing his surgeries at Christ. But
from Christ's perspective, and Christ is the appellee here, from Christ's perspective, you've sued them twice in the same forum, and you forced them to defend the same litigation 2 different places. And I think that's the crux of what the trial court found was problematic and warranted sanctions.
We indicated to Christ that once everyone was served, we would consolidate the cases and have only one case, leaving us with plaintiff versus Droney, Christ, and Children's Hospital. I mean, the point here was not an evil motive to duplicate litigation. We wanted to consolidate all along. The judge, trial court, acknowledged that, and we were just following an option that was available to us under the Supreme Court case of Russo. If you have duplicate cases in the same form, let alone the same judges we had here, it would be easy to consolidate, sort out the cases that needed to be sorted
But I
out.
don't think Russo like was sanctioning a multiplicity of litigation. I mean,
No, it
because
wasn't.
that creates a lot of problems. If you're going to sue me and you sue me 3 times in the same forum, I mean, that can't be right.
Well, it was only twice. We wanted to avoid the lengthy period of time to file many motions to amend a complaint to bring in uh, children's. And, excuse me, but by having a duplicate case against Christ, and we told the Christ attorneys, we just want to get these claims filed. We're going to consolidate. We don't want to bring on additional unnecessary litigation costs. We just want.
But see, I'm sorry, go ahead, Judge Bach.
Yes, ma'am.
Why didn't you dismiss the duplicative cases then?
As it turned out, I think we did settle with Children's and those
But then
claims.
didn't you
were
refile again in March 2016?
Well, I'm going to mess this
My
up.
understanding was that you refused until after Children's filed a motion to dismiss, then you voluntarily dismissed, but then you refiled.
I mean, the point was to get a case involving Christ and Children's and Durrani in one case, consolidate them with the existing cases, and dismiss the ones that needed to be dismissed. And I'm sure Ms. Mitchell will tell you that some needed to be dismissed, and they were. I think Christiansburg comes to mind immediately, and there are several others, and they were. But we wanted to avoid a huge paper mill of filing motions to amend in existing cases that will cause delay, perhaps cause statute of repose time to run as to Children's. So that's where we were headed. And I didn't see any bad faith. It wasn't, we knew that thought we could consolidate under Rule 42. The Russo case, although not a sanctions case, indicated that consolidation is one of the tools that the trial court has to remedy this situation. And that we used that in that Baker case, and it got that.
But I think part of my concern here is
Yes,
that following up on Judge Bach's question, like you didn't, if you did it properly to begin with, you didn't dismiss it when you should have, and you forced Christ to continue to litigate. In fact, I recall we had an appeal of the consolidation issue, and we get to this appeal, there's judicial resources are expended. I'm sure Christ spent resources on that. And then you all told us it was moot. So like, it wasn't like as soon as you had the opportunity, you dismissed it and everything was in one action. It was this disparate path for the two proceedings.
What we had then was the propriety of not using the tool of consolidation. It was moot. The appeal was moot because we successfully settled with Children's, which was one of the goals all along. But had we not settled, then the issue of consolidation would have been decided back then, Judge Bergeron, not now. Like I said, we rather than try to use the consolidation tool, we were fought all the way, and hence attorneys' fees were rung up, I'll reclaim needlessly. The the last 2 points I wanted to make was, all right, if there are sanctions to be imposed, 2 of them are not appropriate. The first is any fees brought incurred while we were on appeal. I think that there is $8,000 and change claim to be incurred at the first district. That's, this court decides whether or not fees are appropriate or not. The litigation in which those fees were incurred has come and gone. Those matters should have been brought up then. Second of all, a 4-digit fee was incurred by Christ in removal to the federal district court. That was remanded. Fees incurred in federal district court first are decided by the federal district judge, not here. And second of all, we prevailed. The case was remanded from the federal district court back to Ohio State Court. They were the losers. We won. They don't get fees for that, for their effort in trying to take it to federal court. And that is, do I have 3 minutes left?
You do have 3 minutes left.
I think I will hold them. Thank you, Judge.
Okay, thank you. Ms. Mitchell.
Good morning, Your Honors. On behalf of the Christ Hospital, I'm Jen Mitchell. And I think I wanted to sort of address in reverse order the arguments of Mr. Winter, and then also just point out that the standard of review on an appeal is abuse of discretion, as you well know, and that if a court has exercised its discretion and exhibiting a sound, reasoned process that would support its decision, which it has in this case, this court should not disturb that determination on appeal. So just briefly talking about how this case came about and Christ's involvement in it. As Judge Bergeron pointed out, this case did not originally involve the Christ Hospital. It was a case brought against Children's Hospital. And as Mr. Winter argued, you heard him talk about the justifications for why this case was filed, and it all relates to Children's Hospital. And so from the very outset of this litigation, Christ was named in a lawsuit that was entirely duplicative of other individual lawsuits that were either pending or, more egregiously, really had already been decided on the merits by the trial courts in several instances, and still, again, filed against the Christ Hospital in that refiling. So when the case was originally filed in, I believe it was 2014, December of 2014, it involved only Children's Hospital. The Christ Hospital never took a position as to whether or not that was an appropriate lawsuit, because we didn't represent Children's, we represented Christ. So throughout and from the very beginning, I had communications with counsel for the plaintiffs asking for dismissal. I had telephone conversations and emails that are part of the record that demonstrate that we made multiple requests before filing a motion to dismiss this lawsuit, that it be dismissed because it was duplicative and frivolous. And those requests were rebuffed with responses in large part saying that they had valid claims against Children's. It didn't really address that from the outset they never had valid claims against Christ. So we were forced to do what we had to do, which was file a motion to dismiss. There was no opposition ever filed to that motion to dismiss, and it was granted ultimately by the court. In the meantime, though, there were communications and there were court conferences that were attended where we implored plaintiffs' counsel. We asked the court to dismiss the claims against the Christ Hospital. The court even sent a lengthy email that is also part of the record in September of 2017, asking the plaintiffs why the case was continuing as to the Christ Hospital and indicating that it was duplicative because there were other individual lawsuits. So as the case proceeded, the plaintiffs at many junctures had an opportunity to dismiss the Christ Hospital so as not to incur all of the costs associated with defending this case. And when the court ultimately issued its ruling after a hearing and the presentation of expert testimony as to the validity of the attorney's fees incurred by Christ Hospital, the court awarded all attorney's fees incurred by the Christ Hospital as of June 17, 2019, which was the date of the hearing. When the case proceeded, our motion for sanctions was ultimately, the decision, again, on the Christ Hospital's motion to dismiss is, and I think the timing is important too, was October 30th of 2018. So that decision granting the motion to dismiss came down. And then in that decision, the court indicated that were a motion for sanctions to be filed, that it would entertain sanctions at that time. On December 3rd, 2018, the motion for sanctions was filed. At that point, they still could have aborted their mission of including the Christ Hospital in this litigation, and they chose not to. 10 days later, on December 13th, 2018, the plaintiffs appealed the trial court's dismissal on grounds that the lawsuit was duplicative and shouldn't have been filed. So again, when the plaintiffs on appeal now as appellants are arguing that the trial court should not have awarded costs associated with an appeal, I would submit that the court was well within its discretion to award all attorney's fees that came as a result of the improper inclusion of the Christ Hospital in this litigation from the outset, up through and including what had then been incurred as of June 17, 2019, which was some of the activity on appeal of this.
Ms. Mitchell, your point about the fees for appeal makes more sense to me than the removal fees. So could you address Mr. Winter's concern about that?
Yes, I think the argument is very similar. So if Christ Hospital hadn't been included in this lawsuit from the outset, it wouldn't have had to tag along with Children's Hospital when it chose to remove this as a mass action because it involved 36 plaintiffs. So while the Christ Hospital was involved in the removal, it was as a result of it being needlessly named in this lawsuit from the outset. The removal also was not ultimately determined by the federal court to be frivolous. The removal ultimately was not permitted. But again, the costs to Christ Hospital incurred in that removal were by virtue of the fact that they were named in the first place and they were tagging along with Children's Hospital.
And so if Children's made the decision to remove, they had to get your consent to removal, right?
Right. And again, as occurred, we did consent to the removal at that time and to the process. We thought there were valid grounds that if for some reason the claims would be permitted to proceed, that they should be considered mass action because they involved 36 individual plaintiffs separately. So we did ultimately consent. But again, were Christ not named, it would not have been required to be there at all or incur those attorney's fees.
But Ms. Mitchell, the federal court didn't find that it was frivolous, but the federal court did find it wasn't justified. I mean, bottom line, you didn't win that part of the action. I'm struggling to see why we should award attorney's fees for an action that you didn't, the piece of the action that you didn't win.
So again, the fact that we won or didn't win or lose really isn't, from my perspective, the ultimate issue. It's whether or not we would have had to incur those fees at all.
But you wouldn't have had to had you not done something that really wasn't justified in the first place.
Well, I don't think that the court said that it wasn't justified. It just exercised its discretion not to allow the case to be removed. Plaintiffs also, if they had believed that they should have been awarded some sort of fee or sanction relating to that removal, they could have pursued that and did not. So again, from the perspective of the Christ Hospital, everything that it had to spend to defend this particular case is a byproduct of the fact that the plaintiffs should never have named the Christ Hospital in this case in the first instance. And we had multiple times early on and throughout sought to have them dismiss the Christ Hospital with never really any explanation as to why it was not only filed, but also continued by Mr. Moran up through and including the appeal that was ultimately determined to be moot by this court back, I think.
And Ms. Mitchell, did you, I'm getting a little jumbled on the timing. Did you make the affirmative request to dismiss Christ prior to the removal?
I again, and I am not certain on the timing of the removal either. So I apologize. I don't know that I have that fact in there to clarify things for you. I can tell you this, that the lawsuit was refiled on March 1st, 2016. And I was having communications verbally and via email with plaintiff's counsel, Matthew Hammer at that time, around March 28th and 29th. And then our motion to dismiss was ultimately filed on April 4th of 2016. I believe the removal came by Children's sometime considerably thereafter, Children's suggestion considerably thereafter. And so there, again, were multiple times, and it's evidence that we were intending to proceed in the state court with this case. And again, were flatly refused dismissal despite having detailed emails and conversations that, look, you've got these lawsuits already filed. Some of them have been dismissed with prejudice already. All of them are duplicative. There's no need for Christ to be named. I think the error occurred right from the outset. We pointed it out right from the outset, and it was never rectified despite repeated attempts to do so over a period of years. So that by the time we got to June of 2019 and the court was ruling on our motion, the court said, we're going to award the amount of attorney's fees incurred by the Christ Hospital. We had an expert testify as to the reasonableness of those, and that our rate of $225 an hour, I believe at that time, was also reasonable. And then they had no rebuttal testimony as to any of our evidence put on with respect to the amount of fees that were awarded. So again, the court then issued several decisions awarding attorneys fees pursuant against Dieter's law, Mr. Hammer, Mr. Moran, and Mr. Johnson for violating 2323-51, and ordered those to be paid jointly and separately. They were then appealed, and that's where we end up here today. For all of the reasons set forth in our brief, and as I've argued, we would respectfully request that this court affirm the trial court's award of attorney's fees to the Christ Hospital in their entirety. Thank you.
Okay, thank you, Ms. Mitchell. Mr. Winter, you have 3 minutes of rebuttal.
Thank you, Your Honor. Attorney fee awards for frivolous appeals are governed by Appellate Rule 23, and that is the civil rules do not apply in to matters in appellate court. The last thing I like to say is there was just no consideration taken by the trial judge of our concerns about the statute of repose. He was well aware of those issues. We asked him to allow us to consolidate. It was just rejected, and Ms. Mitchell has detailed what happened from their perspective rather than give us any consideration about consolidating and then sorting things out. And that's my case. I ask that the judgment for sanctions against the defendants be reversed.
Okay, thank you, Mr. Winter, and thank you both, counsel, for your arguments today. The case will be submitted and we'll issue a timely written decision. We hope you both have a great day.